I am Mr. Obsidian. Prepare yourself for the Man of Black.
Ernesto A. Miranda, petitioner versus Arizona. Mr. Nedred.
Mr. Chief Justice, the pleas of the court, my name is Dwayne Nedred. I'm counsel for the Amicus National District Attorneys Association. My co-counsel is Ms. Oberto. I thought that her presence might show that prosecuting attorneys are not all bad, or she wouldn't be working for us on a full-time basis. I may use some words of one of the justices of this Supreme Court. The Escobedo decision and the Dorado interpretation makes it more necessary than ever that we stop and look where we are going. If we are talking about equality between the rich and the poor, we are striving for a worthy objective. If we are talking about equality between the policeman and the criminal, we are on dangerous ground. I would remind this court that we are not talking about the police versus the defendant. We are talking about the people versus the defendant. In the same way that we would not talk about the Army or the Marine Corps versus the Viet Cong, but we would talk about the United States versus the Viet Cong. I have not mentioned in my brief anything about the Fifth or the Sixth Amendment. I concede that this court can interpret those amendments in the way that it sees fit. I am willing to agree with the ACLU in their brief in one point, where they quote me, although they do misquote me when they refer to Malloy and Haynes in substitution for on page 26 of their brief instead of Haley and Payne, whom I consider entirely different. That an admonishment in the Dorado interpretation will not affect materially confessions. If this is to be our objective, to limit the use of the confession in criminal cases, then you are taking from the police the most important piece of evidence in every case that they bring before a court of justice. Police officers are public servants. They are not attempting to put innocent people in jail. They want to follow the dictates of this court, and they will follow them to the best of their ability, but they too are human beings. They do have, however, an experience and knowledge, which many of us lack because this is their job in investigation of crime. And we have not, as lawyers, paid attention to their problems. We have seldom been down to the police station and asked, what can we do to assist you in your problems? We are more inclined, and I talk about the prosecuting attorneys, and I am not referring to this court any more than any other lawyer in the United States. In the case, if I may use the present case of Miranda as an example, the defense admits that there is a voluntary confession. He says that we should not allow this confession because he did not have counsel present, because we would not have been able to convict him, because there was no other evidence except his own voluntary statement that his male organ had penetrated a half an inch. Otherwise, he would have been acquitted. Is this what we are looking for? To acquit Miranda because he did not have counsel? The amicus here has presented data covering thousands of man-hours on the part of the members, attempting to show the widespread use of confessions. I am not saying that the widespread use of confessions justifies their use. I am just attempting to present to you, through our members, the importance of the confession in our criminal administration of justice. I believe that there is something beyond that which we are discussing here. I think that there is a need, and I have mentioned this and I pray for it, that all public servants, law enforcement officers and prosecuting attorneys, trial courts and members of this court, work together. We are not adversaries. There is a need, I think, on the part of the people to be able to refer to my policemen, our police, my court, and not those cops.
You think we ought to overrule Escobedo?
Sir.
Is it your position that we should overrule Escobedo?
If I knew what Escobedo meant, I may say so. But I have said in my brief, Mr. Justice Court, that I think that Escobedo should never have been appealed in the facts of the case. I think that this court rightly reversed the case on the facts.
You're not urging that we overrule Escobedo?
No, sir. It's a system, our system of justice, in effect, which we need as a matter of change. I do not attempt to say that defense counsel is wrong when they attempt to do the best they can for counsel. This is our system of justice. But I could tell you, for example, in the state of New York, that when a defense counsel is picked by those who are in the profession of crime, I can use this, that they wonder who is hot, for example, in winning cases now, and they are picked almost like as if they were racehorses, because now they are winning. There is nothing so fickle as a criminal defendant. He wants only one thing: he wants to win. Now, if a prosecuting attorney only wants to win, then we should not have that prosecuting attorney in office. We should make a change.
May I ask you this, please, Mr. Nedrud, if you agree on the facts that Escobedo should have been reversed, what would you say as to the man who did not have a lawyer, but who said he wanted a lawyer before he talked?
If he asked for a lawyer and he does not waive his right to counsel, I think that he should have a lawyer. I think that even the state should have, I would go so far as to say I think the state should appoint him a lawyer if he asked for a lawyer. I do not think, however, that we should in effect encourage him to have a lawyer.
And why do you say we should not encourage him to have a lawyer? Are lawyers a menace?
Mr. Chief Justice, a lawyer must, in our system of justice, must attempt to free the defendant. This is his job.
Because it's his professional duty to raise any defenses the man has.
Yes, sir.
Do you think in doing that he's a menace to our administration of justice?
I think that he is not a menace at the trial level. He is not a menace per se, but he is, in doing his duty, is going to prevent a confession from being obtained.
When does he cease being a menace?
Mr. Chief Justice, I did not say he was a menace.
Well, you said he did. He did if he injected himself into it before the trial level.
I merely said that he, in effect, will prevent a confession from being obtained. And if this is what we are looking for, then we should appoint a counsel even before the arrest stage. Because the moment that a murder takes place, the government is out looking for the criminal.
Well, if a lawyer, as you say, he's entitled to a lawyer under the facts of Escobedo, and the lawyer is entitled to tell him that he doesn't want him to talk to the police, why would it be a menace for another lawyer whom the defendant wanted to do the same thing?
Mr. Chief Justice, I'm not disagreeing with you one iota. I am just saying that if, in effect, that this is what should be done, if you want to equalize, for example, the defendant's right against the policeman, Naturally, he should have counsel, if this is what we are striving for.
Well, suppose we put it on the basis of not equalizing anything or balancing anything, but on protecting the constitutional rights of the defendant, not to be compelled to convict himself on his own testimony.
Mr. Chief Justice, I, of course, do not interpret the Constitution. This is, of course, your prerogative, sir.
How do you interpret it?
I do not interpret that the defendant is entitled to a lawyer until the trial stage.
When does that, until the trial starts?
Yes, sir.
And where do you get that authority?
As I read the Constitution, you asked me my opinion. I said I have no authority to interpret the Constitution. I am saying that this is the way I read the Constitution.
Has that been the way this court has read the Constitution in days gone by?
I believe so.
Well, counsel, everybody knows that if he's appointed a lawyer at the beginning of the trial, that the lawyer can't possibly represent him. He needs time to prepare for trial.
Yes, sir.
So the appointment must be at some point anterior to the trial.
Well, Mr. Chief Douglas,
And our question here is, at what point? How far anterior?
Mr. Justice Douglas, I am not concerned when the lawyers enter the stage, and maybe part of our problem is that the prosecuting attorney enters before he should.
And under the procedures in some states, as you well know, very important rights can be lost prior, many days, many weeks prior to the trial.
Mr. Justice Douglas.
So we come down to the question as to dealing with the Constitution that conceitedly, I would think we'd say conceitedly, everyone is entitled to a lawyer at the trial and also at some point anterior to the trial.
The question comes, I think, Mr. Justice Douglas, whether or not we are going to allow the trial court to determine the guilt or innocence or the defense counsel. If the defense counsel comes in at the arrest stage, he will, as he should, prevent the defendant from confessing to his crime, and you will have fewer convictions. If this is what is wanted, this is what will occur.
I guess there's no doubt that the provision which provides for the protection against giving compelled testimony as a consequence, fewer convictions.
Justice Black, this is true. However, again, we're talking about the voluntary-involuntary rule, and I have not questioned this whatsoever. This is, I believe, a good rule. I have said that Mapp versus Ohio is a good rule. I believe, however, that there is a point of diminishing returns, and that at some stage, the police must be in a position to protect us.
Some stage, according to our opinion, he's entitled to a lawyer at some stage. And we've said, as I recall it, haven't we, that that's at the stage when he needs it.
Well, again...
At least after he's been detained. What about the point where a man is seized by government agents, and they are, as you say, they are our agents.
Yes.
They are our officers. There's no antagonism. But what about the fact that when they're seized by someone who has power to detain them, keep them away from his friends, their relatives, and in seclusion if it's desired? Can you think of any time when you need a lawyer more than that? At the point of detention.
Mr. Justice Black, again, the question is, are we interested in convicting the defendant, or are we interested in protecting or acquitting him? This is the only point that I can in effect make. If you say that this defendant needs counsel at this time, for example, let me, if I may use this illustration. I worked when I was a professor of law, which I was prior to taking this position. I worked on the defense project for the American Bar Association, and in the questionnaire, there was a statement, when is the ideal time for counsel to be appointed for the defendant? The question is, when is the ideal time for whom? The people or the defendant? Now, if it is for the defendant, then it is the earliest possible opportunity. If it is for the people, It should not be until a critical stage. If it is White versus Maryland, I agree. It should be at the preliminary hearing stage. If it is in the question of arraignment, as in Alabama, I agree. If it is at the trial stage and he has lost none of his rights, which can be interpreted in one way or another, then I say that it should be at the trial stage.
Well, as a prosecutor, I've found out over many years it's a very critical stage when a person is taken to a police headquarters. Nothing wrong with it. That's our part of our government. Taken to a police headquarters under arrest or under detention. You can't leave unless you want to, unless they will let it. Would you call that voluntary for him then, for them to have him there in that situation? And told him about the probable conviction of a crime. Would you think of that as voluntary?
Being voluntary in the police station? No.
I suppose you'd say, wouldn't you? It's a question of fact for somebody to decide.
Well, I would.
In the context of the different circumstances that have arisen.
I would hope, Mr. Justice Harlan, that this court has protected, as I refer to in mine, the Rex and the Pates, by an involuntary rule, the totality of circumstances. And I hope that this court will also continue to invoke this rule, but not go so far as to prevent the police from protecting us.
I am Mr. Obsidian. Prepare yourself for the Man of Black.